Hello friends, welcome to Talent Hub Training Institute FinSolve segment. How are you? Hope all of you are safe and at your home. We know that in this present scenario, many of you want to start your own business. But then you find lots of legal challenges and lots of option is also there. So taking decision is a bit tough. I know. Here we are trying to solve this problem by simple understanding of business-oriented legal compliance. For this, we introduce a video session with different videos. And overall above, from here you can take a certification by completing this session just via online exam. Every video description will provide the link, but we request to all of our viewers first go through all the 8 video sessions, then avail the test for better result, because we will only provide the certification for those who will secure the 60% of marks. So let's start our session.
Today we will discuss intellectual properties in a simple manner. It also includes understanding the concepts involved in it: trademark, copyright, and patents. Intellectual property, IP, signifies a property or a creation straight out of your mind or intellect. It could be amongst a variety of things that can give your business a commercial edge. For example, an innovation or invention in product or process, a unique identity for a brand, a novel creation of artistic work or design, etc. However, to protect it, you will need to formally register your IP, as this will ensure a legal ownership. Let us discuss the major types of IP. There are 3 ways to secure an IP, which are through a trademark, a patent, and a copyright. Let's talk about a trademark. A trademark is any unique element that helps your users to identify and distinguish your brand or product from the competition. It is ideally a good use case for trademark registration. It can be your logo, jingle, smell, and more. A trademark helps you establish a unique identity for your brand. A patent. A patent is an invention or an innovation that has a useful purpose, offers novelty, and is non-obvious, hence offering a higher possibility of being patented. It can be a novel process, tool, machine, formulation, or an improvement to an existing invention. Copyrights. Copyrights give an exclusive and assignable legal right to the creator for ideas expressed in any form. Copyright protection applies to various forms, but most commonly to original artwork, literary work, music material, etc. The Copyright Act naturally creates a protection on first out basis, where publishing of literary and artistic work carries an economic sense. However, registration adds significant value. Let us talk about trademark. What all can you apply for? The following can be registered as a trademark. Logos. It can be an abstract word or an image, a coined word, a specific font size or style, or even a combination of all. For example, Coca-Cola, for its name written in a particular font and style. A tagline, a phrase associated with the business. As an example, we may consider Bajaj. Hamara Bajaj is a trademark tagline. Slogan, it is a term or phrase associated with a particular product. The Bajaj Pulsar, definitely male, is a good example of a slogan. Jingles. A jingle is the sound of a metal or minimum glass clattering against itself that helps people associate the sound with the brand. For example, Britannia's jingle. A peculiar smell. For example, a perfume by any famous brand. Unconventional marks include colors. For example, Cadbury's Dairy Milk wrapper. A sound mark. Example, the Nokia phone brand's Start sound. A hologram. Intel's hologram on systems powered by Intel. A motion mark. Example, Microsoft's logo that flutters like a flag. Let's talk about patent. What all is included? Invention. Any invention to be considered as a patent should be novel. This novelty can be through a process or improvement or innovation of a new machine. Innovation. Creating anything novel that has new characteristics or an element which is not existing in the prior arts is considered as an innovation worthy to be patented. New process. Any new process or invention that improves the efficiency of an existing one by adding new characteristics, is non-obvious, and has industrial utility, can be patented. Inventive step. Introducing a new step in the already existing process or mechanism that is not obvious to an individual belonging to the technical field and offers advanced technical solution of a problem. Let's discuss copyright. What all does it cover? A copyright work covers a wide variety that is protected by IP law. It can be classified in the 5 categories, that is literary work, artistic works, dramatic works, musical works, sound recording, and cinematograph film. Let's understand each one in brief. Literary works. IPR considers original creations of literature in any form such as books, lectures, plays, novels, poetry, thesis, computer database, and lots more. Artistic works. This includes original work of art created by artists. This can include drawing, painting, sketching, etchings, sculptures, lithographs, architectural designs, photographs, plan sketches, etc. Dramatic works can include original work of scenic arrangements or acting based on literary work. The following can be included: choreography, speeches, dramatics, acting, stage performance, etc. Musical works include original works of music that do not include any lyrics or sound. This contains a symphony, music notations, or harmony in printed or written form, etc. Sound recording. Original work that includes the singer's voice and lyrics. This includes the following: songs, recorded speech, audio, podcast, etc. Cinematograph film. The scope is limited to the original work of visual recording, video, moving visual images, movie, etc. Now let us come to the validity of the IP. Trademark validity. A trademark registration is valid for 10 years. This can be made perpetual as long as it is renewed every 10 years. It is country specific and the owner needs to make a separate application in the country that he or she wishes to avail the protection in. Patent validity. Patent protection is a territorial right and therefore it is valid only within the country of its existence. Separate patenting is required to be filed in each country where protection is required. A patent is valid for 20 years, after which it goes into the public domain. Copyright validity. While it is not mandatory to register, it is highly recommended. The validity of copyright lasts the lifetime of the author and even up to 60 years after his or her death. The owner will be given protection in most countries. World Intellectual Property Organization, also known as WIPO, governs the international registrations of IPR. Trademark is filed as per Madrid Protocol. The PCT, Patent Cooperation Treaty, assists applicants in seeking patent protection internationally. There is no such thing as a global copyright, but the Berne Convention sets the minimum standard of protection for the rights of copyright holders. Having covered the types of IP and the validity, let us look at the benefits it would give. Monetary benefits. There are a few monetary benefits you can avail using your IPRs. This includes selling or licensing your IP for creating an additional revenue stream. It is an asset and you can also claim royalty for your copyrighted works. Some other benefits include offering distinctive products and services to your customers, making IPR an essential part of your marketing or branding as you benefit from the exclusivity, using your trademark for strategic alliances, imposing legal right to defend your IPR in the court of law and claim your sole right on it. You may wonder, when is the right time to register your IP? A wise man would say it was yesterday. Thus, the sooner you do it, the better. It prevents you from losing out on a lot of economic and commercial benefits. Often, others assess and find more value in your business than you do. Never underestimate the value of your business and protect it through IPR. Any such delay leads to business losses in terms of hampered brand image or as an opportunity lost to retain something that you should. IPR also creates a sustainable and defensible differentiator in a highly competitive market. Why is IP important for startups and SMEs? A large portion of startup valuation depends on its IP portfolio. Innovation is the backbone of startups, and guarding it becomes necessary for success and longevity. Brands are built on uniqueness. IPR helps to protect such brands. And lastly, it protects your brand image by controlling the circulation of substandard goods and services in the market. That is it for this chapter. Thank you.